If an employee discloses that they have a disability and then all of a sudden they're being treated differently, they're being isolated or excluded, or their job duties are stripped away, or they're being made fun of or admonished or excessively scrutinized, maybe now they're getting written up or forced on a medical leave of absence because of it, that could be discrimination. I think some people tend to question whether they're overreacting in situations like this because they know they have a disability or a medical condition. They know that they can do their job with reasonable accommodation, and they just want assistance or someone to listen. And they might feel like, well, am I overreacting because I need this accommodation because the employer is unwilling to give it to me? Am I asking too much? So they may not understand that they have a right to ask. If the employer is responding in a negative light, that's on them, not you. Disability discrimination is when an employee comes forward and identifies that they are a qualified individual with either a serious medical condition, a physical disability, or a mental disability, and they need an accommodation to perform the essential functions of their job. And the employer ignores their requests or is negative about their request or terminates them and denies them the ability to work with an accommodation simply because they disclosed their medical condition or physical or mental disability. One of the biggest warning signs that an employee is experiencing discrimination because of their disability is the employer denying their requests for reasonable accommodation without first engaging with that employee in a conversation, in dialogue, in a good faith interactive process to determine whether or not their request was reasonable. If an employee requests a reasonable accommodation and the employer denies that request without first consulting with that employee and talking about the job duties, the job limitations, the medical condition or disability, and how the employee can overcome their job limitations with reasonable accommodation. If the employer fails to go through this process, that's what signals to us that this might be a discrimination lawsuit or claim. Subtle examples that employees might not recognize as disability discrimination is an immediate denial. An immediate denial that the accommodation is unreasonable and the employer can't provide it. There is a process that an employer has to go through to make that decision. And if an employee is just receiving an email that says, unfortunately, we cannot accommodate you with that request, and they didn't go through this whole process, this whole dialogue with the employer, they're missing a step and their rights might be violated in that omission. After an employee discloses that they have a medical condition or physical or mental disability, and the management's demeanor or attitude toward them changes, maybe they're more hostile or aggressive, or they're standoffish, or they're demeaning and making fun of that employee, that could all signal harassment on a basis of a medical condition or physical disability. So it's important to recognize if you're being treated differently all of a sudden just because you disclose that you are a person with a disability or a medical condition. We try to empower employees and let them know that they have a right to disclose their disability or medical condition to a certain extent and request an accommodation. You have a right to work in a workplace where accommodations are discussed, analyzed, assessed that can help facilitate you and enable you to do your job. So it's okay to ask. Don't just give up or quit or perform less of your job duties because you're struggling with certain tasks. Ask for help. The employee should be gathering medical documentation, complaints if they're not being accommodated, their job duties and their job description, and emails, text messages that support that they are communicating with their employer and the employer is simply not communicating back. Documentation is key when we're talking about disability discrimination because we need a lot of it. Written communications are extremely important in disability discrimination cases. It tells the story. And it's necessary for an employee to communicate with the employer via email or text message or something in writing to show what the employee disclosed, what they requested, and then what the employer did in response to that. When proving disability discrimination, we need to establish that the person is an individual with a physical or mental disability or a medical condition. They have medical documentation to substantiate this claim, and they have job limitations, which are identified by the medical provider. They've given the employer this information, and in response to that, the employer does not engage in the good faith interactive process, or they subject that employee to adverse action. Employers often deny reasonable accommodations because they say that it's based on business necessity or undue hardship on the employer. And so they try to defend that they can't provide this reasonable accommodation because it would be undue hardship on them. But what we're looking at as actionable discrimination is an employee has a disability, they've requested a reasonable accommodation, and the employer simply denies it without going through an interactive process to determine whether or not it's reasonable. So there's steps an employer has to take once an employee requests a reasonable accommodation. If the employer simply ignores it and doesn't go through the mandatory process, that could be a discrimination case. The right time to seek legal advice when you feel like you're being subjected to disability discrimination is immediately following the adverse action, whether it's write-ups, disciplinary action, termination, forced medical leave. Talk to an attorney to see if the employer is complying, or if the employer completely ignores your request for reasonable accommodation and they just stop talking to you, that could be a sign. Waiting too long can make it hard to prove a disability discrimination case because they might not have the documentation or evidence they need, or they may have a statute of limitations issue. So it's important to seek advice as soon as possible. I wish every employee knew that they had a right to equal employment opportunities, that despite their disability or medical condition, they have a right to work and they're protected, and they have a right to request reasonable accommodations. Don't be scared.